course, there was the prosecution of the first World Trade Center bombing, the prosecution of the embassy bombings, the bombings in '98 led to prosecutions in 2000. You had the most competent, qualified, experienced FBI agents in the country were working in that office. They spoke the language. They didn't need to use interpreters. They knew the personnel, the actors, backwards and forwards, and the same thing in the prosecutor's office. And the principal prosecutor there was Patrick Fitzgerald, who's now the U.S. attorney in Chicago. They jettisoned that. They jettisoned that perspective. The idea was that the Clintonian model was a failure because, as evidenced by buildings falling from the sky, it did not prevent that. And it was principally directed towards fixing responsibility for a past event. They were not interested in that. They were interested in penetrating the problem in order to prevent a future event. It is an intelligence problem that we will meet with the arsenal of military intelligence rather than a law enforcement problem that we will meet with the arsenal of criminal prosecutions. That's the perspective. So the question one needs to ask in order to understand this world is, what environment do they want to create in order to get intelligence from people that are going to come into their custody? Because they knew very early on, they knew September 12th that there was going to be a military response. There was going to be boots on the ground. And if there's boots on the ground, every military planner knows you're going to have prisoners. And if you have prisoners, you have the capacity to extract intelligence. And it was not just DOD, that is military, but it was also CIA, because we know that now that September 17th, the president signed an executive order, an order that remains classified. No one's seen it, at least no one's publicly described it, that authorized the CIA to get in the business of interrogating prisoners as well as rendering them. And Joanne Mariner is going to talk about the rendition program tomorrow. We're very lucky to have her here. So I don't want to talk about that. But we knew that we were going to be getting prisoners. They represented a source for a potential source for information, and our objective was to extract all that information. And as policymakers, from their perspective, they could leave no piece of information unsecured, because they didn't know whether the information that was left on the table unlearned is what prevented the next attack. That was their orientation. So the question is what environment one creates that they believed was necessary to get that information from prisoners that they're going to. Okay, so what do they want to do? This is the most fateful step in understanding the administration's detention policy. They came to the conclusion that you need to create a particular kind of environment to maximize the intelligence gathering process, the interrogation process. And that is an environment characterized by anxiety, fear, debility, dread. It is an environment of such overwhelming tension that the belief was you would create such a sense of turmoil in the prisoner that they would lose any capacity they have to resist the conventional blandishments to interrogation. They would be unable to resist the pressure applied on them during interrogations, and they would finally give up the information. In the elemental battle between interrogator and prisoner, between interrogator and subject, interrogator wants the information, prisoner doesn't want to disclose it, you need to skew the odds in favor of the interrogator by weakening the prisoner. And you weaken him psychologically, you weaken him morally, you weaken him physically, by creating this anxiety of this environment of extraordinary anxiety. Because no human being can long tolerate that. That is the lesson of interrogation history. So what does that translate to? It translates to a very deliberate creation, very deliberate. Everything about Guantanamo was extraordinarily deliberate, of an environment of hopelessness and fear. And the fact, the event that captures that best for me, there are many, everything that we've seen down there, by the way, is consistent with this, and in fact, the very reason that it was at Guantanamo and not within the mainland, for instance, is to facilitate this, because they believe that if it was at Guantanamo, it would not be within the jurisdiction of the courts, and so you wouldn't have judges overseeing the interrogations. You wouldn't have lawyers going down there and talking to prisoners. Why? Because that interferes with the environment they're trying to create. All right. One thing that captures this the best for me, in 2004, a memo surfaced. It was a memo written by interrogators to senior analysts at Guantanamo shortly after prisoners arrived. The prisoners began to arrive at the base in January 11th of 2002. So many of the prisoners that are there are now entering into their 6th year. And the question was this. It seems that in many Muslim and Arab countries, orange jumpsuits, the prison garb, as you've all seen the pictures, I presume, orange prison garb is worn by prisoners who have been condemned. Prisoners who are going to die wear orange. And the prisoners, when they first came to Cuba, they didn't even know they were in Cuba, by the way. They thought they were brought here to be executed, and they were terrified. And the memo said to a senior analyst, the prisoners all think they're going to be killed. Should we tell them the truth? At no time in U.S. military or intelligence gathering history has that question ever been put. Why? Because you would never create an environment where you would willfully have prisoners believing, as a deliberate policy, that they were going to be killed. But post 9/11 is a different world. And so not only was the question put, the answer was, should we tell them? No, you should not tell them. Wait until the first few rounds of interrogation. Why? Because you want to create an environment of terror. I want to examine this more closely because all of us should understand that this is not merely an abstraction. To my students, and I know because Mr. Ellsberg asked for a show of hands of how many lawyers there were, and mercifully there were very few, and for that I commend you. But there was a very famous case. I will put my friend Ms. Mariner on the spot. There's a very famous case called McCullough versus Maryland, and one of the most famous lines in McCullough versus Maryland, Joanne, do you remember? Good for you. Justice Marshall, Chief Justice Marshall. He said, this is a constitution. We must remember that this is a constitution we are expounding. And law professors are fond of quoting that, or this was sort of almost rabbinical authority, as, oh, this is a constitution we are expounding, as though just to say it, and students are supposed to stroke their chin knowingly, yes, and no one really knows what it means. And I always tell my students to remember and not to get too wrapped up in the X versus Y, the issue, the case, to remember that this is a human being we are defending. And my first trip to the base was in November of 2004. I went down to see my client. His name is Mamdouh Habib. Mr. Habib is Australian. He was born in Egypt, but he's lived the last several decades of his life in Sydney, Australia. He's an Australian citizen. He didn't even know, this is November of 2004, we had won the decision in Rasul in late June of 2004. Mamdouh did not even know that he had been the subject of the lawsuit. He did not even know that the Supreme Court had written about him. He did not know that he had won. And I was going down to see him, and he had no reason to trust me. He had no reason to believe he had been lied to. He had been rendered to Egypt before he was brought to Guantanamo, where he was there subjected to the most ingenious interrogations and tortures that I have ever heard of. And he had no reason to believe that I was who I claimed to be. And so the question became how, in this environment, we would establish a relationship that you understand as one of attorney-client, where I could be his counselor and act as his agent in the world. And what we decided to do, we as my co-counsel and I in Chicago, is we contacted his wife in Sydney, and we flew her from Sydney to Chicago and met with her for several days with the family lawyer. And to try to convince Maha Habib, his wife, that we were legit, which was the first challenge, and that we had her husband's interest at heart. But we knew that that wouldn't be enough. We got a letter from her in her own hand on plain paper, not on any letterhead. But we knew that said the predictable things, Maha, please, or Mamdouh, you can work with these people. He could have believed that that was secured under duress, right? I mean, we didn't know what condition he was going to be in. So I said to Maha one night after we had been talking, I said, Maha, I want you to go home tonight, and I want you to think of the answers to 3 questions.